Good afternoon, ladies and gentlemen. My name is Jan Klabbers. I'll be your host for the next hour. To introduce the speaker of our Eli Lauterpacht lecture 2025, Santiago Villalpando. I'll say a word about Santiago in a moment. First, a word of gratitude to Ivan and Francesca Berkowitz for sponsoring the event. A lot of. There we are. Santiago, I can call him Santiago, is a bit of a rare beast in the sense that is one of those practitioners in international law who's also very comfortable moving academic circles. And matter of how the coin drops, which probably determined where he ended up. Met the chief of the treaty division at the Office of Legal Affairs of the United Nations. Still one of the best seminars I ever participated in, chaired by him. And it was not due to our presentations, but to the quality of the chairing. Before that, he had spells at the International Court of Justice, at the International Criminal Tribunal for Yugoslavia, at the UN Dispute Tribunal, who is currently legal advisor of UNESCO, very much a hardship posting in a very troubled part of Paris. Santiago has been a member of the Institut de Droit International since 2021, or so it says online, so it must be true. Holds a PhD from the Graduate Institute in Geneva, which is a place close to my heart as well, and a master's degree from Luis in Rome, which is also close to my heart. It's amazing how much overlap there is. He's been with the Leiden Journal for about a decade, giving the street credibility to the academic credentials. My vocabulary is momentarily deserting me, but that happens. Author and editor of several books, including one I had a chapter in the UN, the Oxford Handbook on UN Treaties. And he was, as editor, assigned to me. We had a lot of correspondence going back and forth, and I may have been more stubborn than I should have. So I belatedly apologize. The topic of the lecture, Hard Law in Times of Liquid Modernity, Treaty Law and Practice in the 21st Century, that taps into a lot of my sensibilities, the title alone. So, Santiago, I can't wait. The floor is yours.
Thank you. Thank you very much, and it's a pleasure. And let me say how much of an honor it is to be invited to give this lecture today. It is my first time in Cambridge, which I consider to be an enormous flaw in my career, not to have been here earlier than this. But I'm so happy to be with you today. I'm so happy to see so many friends in this room, this in general. So again, thank you very much. Thank you for that introduction. So I'm going to talk today about what I entitled Hard Law in Times of Liquid Modernity, Law and Practice in the 21st Century. And I'd like to believe that this is a topic that Eli Lauterpacht would have actually liked a lot, because he is often credited as being one of the promoters of a review of the multilateral lawmaking, treaty lawmaking, that was launched by the General Assembly in the Sixth Committee in the 1970s. And when he was taking the floor in 1975 on behalf of Australia at the Sixth Committee of the General Assembly to defend that idea, he said, and so I can go on and say that what he said was that international legislation by treaty making is an art, a complex and flexible technique which has changed as society has changed. And this is the topic of today's lecture: how treaty making has changed as society has changed. Let me explain a little bit what I'm thinking and what I mean. A few years ago, my wife's best friend was in a muddle. she was coming to Hague for a visit at our home. And she was coming from Argentina, and she knew my wife pretty well and knew very well what to bring for her. But she didn't know me that much, and she had no clue what I would like. So she was wondering what I would like as a gift, and she made a bold move, buying for me a book by a Polish-British sociologist named Zygmunt Bauman, and entitled Liquid Modernity. I remember that this puzzled me and even worried me a little bit at the time, but it turned out that she knew me much better than both of us had thought, since that book triggered for me a reflection that has accompanied me for years about international law and which constitutes the basis of today's lecture. Described in a few words, which I should say is not at all the way Zygmunt Bauman describes it, the concept of liquid modernity lies in the idea that our society has evolved from a traditional solid state characterized by predictable and enduring social structures to a liquid one in which social roles and institutions are fluctuating and unstable. There are numerous illustrations of this around us. In our families, which used to be built around a lifetime marriage, but come today in very different forms. In our professions, where we used to get a job early in life and stay there until retirement. In communication, but now we are not. Now we're changing, and now we're in a more dynamic, a more unstable relationship with professional lives. In communication, which used to rely on very solid books, kept in very solid libraries, while now we are storing information in the cloud, and we consume it through streaming, in surfing the web, all very liquid images. In our relationships, which used to be built around stable social circles and are now relying on ethereal online networks. In our political activity, which used to rely on very stable political parties and now is very much shifting from social movements that are united only for one election or one specific topic. And in the scenery of our lives, where we now move and travel in migrations. What interested me at the time and forms the basis of this lecture is that Bauman also associates this concept of liquid modernity with the erosion of norms and the decline of long-term commitments, which at last leads me to international law and to the subject matter of treaties. Now, treaties appear, after all, to be the epitome of that world that Bauman claims to have been transformed. They are the archetype of what we call hard law, which represent all that is solid and stable about our international order. One may then wonder whether in a world of liquid modernity and erosion of rules, treaties are not themselves being eroded. And many in our discipline seem to have argued so. A few years ago, a former director of the Lauterpacht Institute, James Crawford, wondered whether the world is suffering from treaty fatigue. A decade ago, the American Journal of International Law organized an online agora on the topic, The End of Treaties. And we do see in our daily life several well-known instances of withdrawals from major multilateral treaties, the United States withdrawing from the Paris Agreement, or indeed Brexit, and we also see difficulties in the negotiation of new multilateral treaties, such as the Treaty on Plastic Pollution. So my lecture today is aimed at, sorry about this, it's not working again. So we're going to get rid of the presentation. It doesn't matter that much. So my lecture today is therefore aimed at addressing this question. Are we facing in international law a phenomenon of liquid modernity, which is leading to a decline of treaties as a lawmaking technique? To answer this question, I will first describe the symptoms that are often invoked as evidence of decline of treaties, but show that they're not really conclusive of such a decline. Since I do recognize that something is going on, though, I will then examine what I see as the main challenges to treaties as a lawmaking technique. And finally, I will offer my take about what is happening namely not a decline, but certainly a reframing of the role of treaties in contemporary international. So let me get first to the first point, and I'm going to make my last desperate attempt to make this work.
Yeah, something is happening there.
Something is happening. No, well, we're going to give up. Don't worry. So let's get to the first point. Those who claim that there's a decline of treaties in different trends, they point first out to the fact, they point out first of all, that states seem to be favoring more flexible kinds of arrangements. And this is undoubtedly true. Where 19th century international law seemed to rely almost exclusively on a very stable set of formal treaties adopted through a cumbersome procedure of signature and ratification, today's international affairs are governed by a myriad of flexible arrangements, including memoranda of understanding, joint statements, minutes, letters of intent, institutional arrangements, exchanges of notes. Those that states seem to be favoring non-binding commitments to the traditional strictures of treaty law. I do not believe, however, that the rise in such informal arrangements necessarily entails the finding that treaties are declining. First of all, the phenomenon is, in my view, often overstated. On many instances, these arrangements, while certainly more informal, the phenomenon is, as I was saying, is, in my view, often overstated. On many instances, these arrangements, while certainly more informal than the old-fashioned treaties of the 19th century, remain treaties under international law. Take the example of memoranda of understanding. While it is sometimes claimed that MOU are necessarily non-binding and therefore outside the realm of treaties, the fact is that, at least in certain circumstances, MOUs may be binding. And you don't need to take my word for it. Just read the definition of a treaty in the Vienna Convention of Treaties, and you will discover that, treaties, an agreement, the title of an agreement is conclusive as to its nature. Or read a recent judgment by the International Court of Justice, where it found that an MOU between Kenya and Somalia constituted a binding agreement, therefore a treaty, on the delimitation in the Indian Ocean. But most of all, this claim seems to underestimate the breadth of these international relations. They may be invisible to the untrained eye, but there is an outstanding number of treaties that continue to govern everyday relations between states. In a past position, as was mentioned by Jan, I used to head the UN office that was in charge of the publication of the famous United Nations Treaty Series. Now, when you look at the treaty series, it becomes evident that the conclusion of treaties is far from slowing down. The average number of treaties that were registered with the United Nations in the 1945-1970 period was around 5,000 treaties per decade. More recently, it is more in the range of 10 to 12,000 per decade, so more than 1,000 treaties per year being registered with the United Nations. The fact is that we tend to misjudge the quantity and nature of legal commitments that states agree to on a daily basis. The UN Treaty Series shows that there are certain areas which continue to rely very heavily on treaties, including financial cooperation, double taxation, air traffic, diplomatic privileges and immunities, exemptions of visas, recognition of university diplomas, and of course, investment protection. Remember what investment lawyers keep telling us on and on and on again. There are more than 3,000 bilateral investment treaties in the international community. By the way, it's been too long that they said there are more than 3,000. So either there are many more than 3,000, or they're maybe overestimating what the intensity of that production. A second phenomenon that is often invoked is that the codification of international law has been shifting away from the conventional form. And again, this is true. Many, myself included, have studied this phenomenon. In its early decades, up to the 1980s, the United Nations seemed to be set in a codification of international law through multiple treaties with major conventions, mostly concluded in Vienna in the 1960s, the Vienna Convention on Diplomatic Relations, the Vienna Convention on Consular Relations, and of course, the Vienna Convention on the Law of Peace. But lately, since then, the United Nations seems to be favoring more flexible kinds of non-binding communication instruments, including guidelines, conclusions, recommendations, principles, or even simple studies. And even when the ILC produces ready-to-use draft articles that could be converted into a proper convention, the General Assembly seems to be hesitant and leaves these in an eternal legal purgatory, as is the case with the famous articles on state responsibility. And again, I do not think this is necessarily symptomatic of the decline of treaties. First, lately, as you know, the General Assembly seems to be shifting back to treaties as a form of codification. In 2024, it has decided to go on with the negotiation of treaties, both on the prevention and punishment of crimes against humanity and on the protection of persons in the event of disasters. And in any case, this seems to be a phenomenon proper to codification, which does not necessarily extend to all multilateral treaty making. Indeed, in recent years, we have witnessed the adoption of momentous conventions, including the Paris Agreement on Climate Change, the Treaty on the Prohibition of Nuclear Weapons, the Agreement on Biodiversity Beyond National Jurisdiction, the BBNJ Agreement, or the WHO Agreement on Prevention of Pandemics. And indeed, it might be true that the negotiations for a further agreement on plastic pollution are facing difficulties. They are still ongoing. So I do not think that we're witnessing a decline of treaties, but I do believe that treaties are facing challenges as a law-making technique. Let me focus on two of them. The first challenge comes from the acceleration of customary law. Customary law, the traditional repartition of roles between treaty and custom, the two main sources of international law, was pretty straightforward in a traditional way. Customary law provided a universal foundation to the system, but it took decades and centuries to form, to the point that the very manner in which practice and opinio juris could combine into a custom was shrouded in mystery. Treaties were the fast way of establishing new legal means. If your goal was to regulate a new area of law in a timely manner to guide states' behavior and obtain legal commitments, the only way to go was treaties. In recent years, though, this repartition of roles seems to have been put into question as customary law has started to form faster and faster in a way that, by the way, Bauman would describe as more liquid. Already in 1969, the International Court of Justice had pointed out the way by declaring, with respect to the rules applicable to the North Sea continental shelf, that, and I'm quoting here, the passage of only a short period of time is not necessarily a bar to the formation of a new rule of customary international law. Today, customary rules seem to be emerging in a mere matter of years. For example, in areas such as disarmament, international humanitarian law, environmental law, or cyber law. Impressively, customary law may today come into being even quicker than the time it takes for a multilateral treaty to be negotiated and for it to enter into force. For example, one could claim that by the time the United Nations Convention on the Law of the Sea entered into force in 1994, more than 2 decades after the launch of its negotiations, many of the rules it intended to introduce on the exclusive economic zone or on the continental shelf had already come into being as customary law. This is partly due to the intensification of international relations, their liquefaction, if you so wish. Treaties, there's simply more opportunities for states to interact in today's globalized world, and therefore practice and opinio juris can consolidate much faster than before. But it is also linked to the intensification of international adjudication. Today, we have pronouncements of what international law is from a myriad of judicial and quasi-judicial bodies that have emerged in recent decades. Of course, the International Court of Justice, but also the International Tribunal of the Sea, the WTO appellate body, ICSID arbitral tribunals, international criminal tribunals, administrative tribunals, and the list goes on and on. This is how, for example, the concept by which perpetrators may be criminally responsible for breaches of international humanitarian law in an internal armed conflict, or the idea that sexual violence could be conceived as a war crime, went in a matter of a few years from being an audacious propositions claimed by a handful of scholars to being accepted law, thanks to the pronouncements of the ICTY, the ICTR, or the ICC. A mentor of mine, Luigi Condorelli, called this phenomenon high-speed custom. The second challenge to treaties comes from the spreading of soft law. In a phenomenon that again resembles Bauman's liquid modernity, we have witnessed in recent years the emergence of several categories of instruments which aim at laying down international law in writing, but in a much more flexible way than treaties. And these include declarations, recommendations, resolutions, compacts, guidelines, codes of conduct, action plans, frameworks, best practices, etc. These instruments present a distinct advantage over treaties in that they can be negotiated more quickly and that they do not require the cumbersome processes of parliamentary ratification. Sure, contrary to treaties, they're not legally binding, but very often the advantage of being accepted faster outbalances the possible drawbacks linked with their lack of formal legal value, especially in an international legal order that has no centralized mechanisms of enforcement or compulsory judicial settlement anyway. So, those are two challenges, but the biggest challenge of all comes when these two challenges I just described combine with each other. That is, when soft law instruments and high-speed custom join forces to allow for new rules to develop, which will be written and binding, such in the same way as treaties. This is a phenomenon that has interested me for years. In a nutshell, it consists of a self-catalyzing interaction between political and expert bodies that issue soft law instruments, for example, the General Assembly or the International Law Commission, and judges arbitrators such as the ICJ or investment tribunals that quote each other. So political experts on the one side and judges and arbitration on the other will quote each other repeatedly and accelerate the formation of customary law without any intervention of treaties. This phenomenon has taken place in various areas of international law, such as in basic human rights, with the Universal Declaration of Human Rights being quoted repeatedly by various human rights courts and committees. And let's remember, the Universal Declaration is not a treaty. And by the ILC articles being on state responsibility being consistently referred to by international courts and tribunals for dozens and dozens of times. One of the most glaring examples of this is the defense of the state of necessity in state responsibility, which went in a matter of a couple of decades only from being a fuzzy concept often claimed but never retained to an affirmed principle of state responsibility, which has found several applications in the area of investment law, simply by the back and forth between the International Law Commission and the ICJ, quoting each other until they built this conviction that we have a customary rule there. And all of this while the General Assembly continues to ponder whether it would be a good idea to convoke a diplomatic conference to embed the ILC article of state responsibility into a multilateral treaty. So, if what I am describing is not at a time of treaty, then what is it? In my view, treaties as a lawmaking technique are facing what I would call a Netflix dilemma. I assume you all know what I'm talking about. At one point in time, Netflix's streaming was the disruptive technology which changed the way we consume videos. The technology, by the way, that we can also associate with Bauman's liquid modernity. By forcing the extension of brick-and-mortar video clubs, Netflix quickly acquired a monopoly in how we watched videos and TV series in a faster and more flexible way. But as time has gone by, other companies have emerged that provide alternatives for streaming, which have forced Netflix out of its monopolistic position and did indeed make some believe at one point in time that we were facing its possible demise. The same may be said of treaties in international law. There was a time in which treaties were the disruptive technology of lawmaking that was a source that could produce, contrary to the old-fashioned custom, new rules timely and in writing, thus seeming to pushing customary law to the sidelines of international law. If you wanted to govern the conduct of hostilities in an armed conflict, if you wanted to outlaw war as an instrument of national policy, to ensure the prevention and punishment of the crime of genocide, or to commit or to codify diplomatic and consular relations, there was one sole way to go. Should we conclude the treaty? Of course. What else? It was a situation era of treaties and chill. I know what that means. That's not what I mean. In this framework, custom and soft law are the Hulus and Disney Pluses of international lawmaking. They pose a challenge to that monopoly and offer alternative ways of attaining the same purpose. And in this context, it is natural at first to have the impression that this might mean a decline of treaties. The fact is, however, that both Netflix and treaties have adapted to this new social environment of liquid modernity, and they have done so in two ways. First, by focusing on their competitive advantages, and second, by adjusting their offer to meet the new needs of society. So let me look at these two. This will be the last part of the presentation. First, there's no doubt that treaties continue to enjoy what is known in marketing as a competitive advantage compared to other competing means of lawmaking. In other words, while the question whether treaties are the way to go might no longer be as straightforward as before, there are some cases in which treaties remain the best choice for international lawmakers. For example, if you intend to establish an international organization to ensure the implementation of international commitments, treaties are the way to go. You could make the claim that you can do that in other ways, but treaties are the best way of creating an international organization. If you intend to put into place effective means of dispute settlement to support a legal regime, such an ad hoc arbitration procedure, or the recognition of the compulsory jurisdiction of the International Court of Justice, treaties are the way to go. If you want to ensure that financial resources will support the pursuit of the objectives of a new legal regime, then you should choose treaties which allow you to make a legal commitment in that regard. And if you're introducing rules that will require national legislation for their domestic implementation, for example, in an area such as international criminal law, principle nullum crimen sine lege, then treaties again are a way of showing that those crimes exist internationally. Treaties provide a more secure and efficient tool to attain certain objectives in international relations in a manner that neither soft law instruments or high-speed customary law will be ever able to provide. There are also more intangible reasons to opt for a treaty. Domestically, treaties may simply guarantee a more suitable environment to attain your objectives. A few years ago, I was participating in Bangkok in the negotiations of a new treaty for the promotion of e-commerce in the Asia-Pacific region. I was puzzled by the fact that many smaller states were very passionately pushing for a binding legal instrument instead of what would have appeared to be a much simpler option, a declaration or a recommendation in that regard. So I had gone out in the evening with a group of delegates. We were in one of those famous Bangkok malls, and asked one. I'm probably the only person who, in that kind of situation, asks questions about international law. And I asked him, why was it that his government was so much in favor of concluding a treaty? Wouldn't the soft law declaration be enough for them and much easier to get without so much negotiation and trouble? His answer was money. He said that for his government, it would be much easier to obtain international funding for the implementation of e-commerce from foreign donors or by the United Nations, if that were for the implementation of international legal commitments, instead of a fuzzy declaration that recommended certain ways to go. That's on the domestic level, but internationally, there are also good reasons to opt for a treaty over the natural development of customary law, no matter how quick customary law can be. For smaller states, the negotiation of a multilateral treaty provides them with a greater opportunity to influence the setting of new rules. In the normal aggregation of practice and opinion duties, smaller states have a very limited impact on the formation of customary law. In a multilateral conference, they may join forces in like-minded groups defending the same position for greater impact. The negotiations of the Paris Agreement provide a glaring illustration of this. Small island developing states were able to achieve a major success in pushing forward rules to mitigate and adapt to climate change by joining forces, thus obtaining, for example, the recognition of the ambitious goal of limiting global warming to 1.5 degrees Celsius above pre-industrial levels. I was part of those negotiations, and it was interesting to see how when the United States and the European Union and big countries were to meet and negotiate something, they would say, wait, we need to consult with Barbados. Where else do you have that? Because Barbados was the representative of a big group of small island developing states that were defending a certain position and would be able to push forward a certain agenda in those negotiations. That is probably something that would not happen in the normal aggregation of international customary law. But competitive advantages only tell half of the story, in my view. Both Netflix and treaties have also read the room and adjusted their offering to the new needs of society. As far as treaties are concerned, they have adapted to their new liquid environment by becoming themselves more liquid. There are countless examples of how contemporary law, treaty law, and practice has become more flexible than it has ever been. In the conclusion and entry into force of treaties, the long and cumbersome process of parliamentary ratification is often abandoned in favor of a streamlined procedure by which treaties enter into force by simple signature for exchanges of letters. In the negotiation of diplomatic conferences, the dangerous and divisive technique of voting on each proposal has been replaced by a package deal approach where delegations strive to reach an overall consensus, providing a more stable compromise among divergent political stances. Again, this is much liquid than it was before. In their title, treaties are most often not called treaties any longer. Negotiators prefer more fluid and yet indeed more ambiguous titles such as agreements, arrangements, minutes, MOUs, standings, joint statements, and so on. In their drafting, treaty provisions often no longer have that crisp and prescriptive formulation of all times. They have been replaced by never-ending formulas reflecting carefully attained compromises. And here I cannot resist the pleasure of reading to you my favorite provision of the Paris Agreement on Climate Change. Let me quote. Parties acknowledge that adaptation action should follow a country-driven, gender-responsive, participatory, and fully transparent approach, taking into consideration vulnerable groups, communities, and ecosystems, and should be based on and guided by the best available science and, as appropriate, traditional knowledge of indigenous peoples, and local knowledge systems with a view to integrating adaptation into relevant socioeconomic and environmental policies and actions where appropriate.
That's good.
Tell me if this doesn't sound liquid. In their form, the monolithic structure of the classical treaties, a set of articles, has often been replaced with a patchwork of different kinds of instruments. Framework conventions followed by protocols, like the Vienna Convention also later followed by the Montreal Protocol and many other protocols and amendments since. Multilateral treaties are accompanied by annexes, which take the form of schedules of commitments or lists of substances that they can be modified in a much more streamlined process than treaties themselves. Then in their actual commitments, states may unilaterally tailor their obligations under the treaty, accepting the treaty is not accepting it as a whole any longer, not only through reservations, which we know for a long time, but also through various kinds of opt-in and opt-out procedures, which again render the treaty regulation much more agile, but less solid than it was before. In their interpretation, which increasingly relies on techniques that go beyond the reading of the text of the treaty, that's solid stuff, and now take into account evolutive developments in implementation, such as subsequent agreements and subsequent practice, again pointing to a more flexible application of treaty provisions. In their amendments, modern treaties are modified frequently in a manner that would have been unthinkable and even considered contrary to the very spirit of treaty law in other times. Just as an illustration, the 1948 Genocide Convention has never been amended. The Rome Statute of the International Criminal Court was amended as many as 7 times in the first 20 years since its adoption. And more generally, in their adaptation, modern treaties often renounce to provide an exhaustive and definitive regulation of a given topic, but rather leave it up to states to continue their negotiations forever and ever so as to adjust their original commitments to their changing environment in societal or technological terms. This is the whole purpose of the complex institutional structures that often accompany modern multilateral treaties, such as the COPs and the MOPs and scientific committees, technical, financial, compliance, and cooperation bodies that often accompany the creation of a treaty. And in this regard, I find it poetic that in terms of Bauman's ideas, that the recent COP30 was on the UN Framework Convention on Climate Change, was indeed negotiated on the shores of a river. In sum, my argument is that the news about the possible death of treaties are greatly exaggerated. Treaties are not declining as a lawmaking technique in international law. They have rather evolved to adapt to the new liquid environment that characterizes contemporary international relations, both by finding their specific role among new competing means of lawmaking and by adapting their law and practice to the needs of the international community. As Eli Lauterpacht said, they have changed as society has changed. Now, before I conclude, let me briefly address a question that you might all be asking yourselves by now. So what? Why does all this matter? After all, what does it change to say that treaties are declining or only metamorphosing to a new state? Is there anything else in today's lecture than an excuse for me to visit the Christ clock, the church clock? And is there anything more here than a Byzantine scholarly dispute? To answer these questions, let me get back to Zygmunt Bauman. The reason why Bauman had studied the phenomenon of modernity is that in his view, the erosion of stable social structures brings with it a sense of deep anxiety and insecurity in the individual, who becomes lost in their identity and their social relationships. And if you look around you, you may notice that a similar sense of anxiety is very present today among international lawyers. The phenomenon of liquid modernity can indeed also be felt in the international legal order, with a challenge to existing global and regional institutions, with a defiance of established values, and indeed with a perceived erosion of formal commitments. In such an environment, emphasizing the continued relevance of treaties as a lawmaking technique is important, because it is to treaties that the international community has always resorted to build back international relations, after periods of turmoil. From the Peace of Westphalia, to the Congress of Vienna, to the Charter of the United Nations. International law has always had this Magna Carta moments in the form of treaties. But the problem is that too often this has only taken place after the scourge of war has brought untold sorrow to humankind. Faced with the danger or reality of these catastrophes today, I believe that our role as international lawyers is not only to defend those values over which our global society is built. Indeed, these values might be changing, but also to convey the message of hope that the international legal order, as a social mechanism, can offer tools to rebuild our world, tools on which we can rely to build back a new sense of stability in a world of liquid modernity. Thank you very much.